Okay, we're on the docket for Monday morning, June 28th, 2021. Quick announcements. We are now on the record. Attorney Alma Garza.
Good morning, Your Honor. Alma Garza, I'm here on number 13 on your docket, Judge. Opposing counsel is Carlos Garza, if he is on.
I am, Your Honor. Carlos Garza for Adolfo Torres Jr.
Okay, that is F 321620-9 in the matter of the marriage of Angelica Torres versus Adolfo Torres. Okay, what is your announcement, Counselor?
Judge, on this one, Mr. Garza and I had been trying to work out the case. I thought it was worked out, but his client decided he wanted one of the children. So we're asking, I didn't know if it would be better to have an attorney ad litem or an amicus, whichever the court thinks would be better to advise the court on possession and custody of the children, Judge.
Okay, Mr. Garza, your response?
Your Honor, I'm in agreement with Ms. Villarreal. I think probably an attorney amicus would be preferable.
Okay, so an amicus attorney?
Yes, ma'am.
Okay, do y'all have an order on file?
I don't know, Judge, but if we don't have one, we'll submit one, Judge. If you want to appoint one, whoever you want, I don't have a preference.
There is an order on file, Judge, although it says attorney ad litem for children. It could be crossed out and said attorney ad amicus.
Well, the duties aren't the same, so as long as...
I'll provide the court with a new order.
Okay, just file an order. I need both of y'all to sign off on that order so that shows me that both of y'all are in agreement with the terms in that order, and then I'll go ahead and assign someone.
Very good.
Okay, so I'll await that to be filed.
Thank you, Judge.
Your Honor, that's all I have.
Okay, thank you. Attorney Daniel Ramirez?
Yes, good morning, Judge.
Good morning, sir.
Judge, I'm here on number 23 on your docket.
Okay.
It's Omar Reyes and Glenda Doster Reyes.
Yes, that is F 2698-20-9 in the matter of the marriage of Omar Reyes and Glenda Reyes. And what is your announcement,
The
Counsel?
announcement is this, Judge. I was representing Ms. Doster Reyes, and then she indicated to me that she didn't require my services anymore. I did file the motion for withdrawal of counsel, and Ms. Doster Reyes approved with her signature the motion for withdrawal. I don't know if she's on the court's live stream this morning, but that's the announcement that it's an agreed motion.
Okay, and Mr. Reyes is still being represented by Jaime Cantu, or who is he being represented by?
To the
Yes.
best of my knowledge, Judge, yes.
Good morning, Your Honor. Yes, this is Jaime Cantu. I'm still representing Mr. Reyes. It's actually an agreed matter. I don't know if the court wants to take it already, or we can just wait to be called.
Okay, but it's an agreed matter as to the motion to withdraw, or it's an agreed matter as to the terms of the divorce?
Both.
Okay, so then is Ms. Reyes on, Glenda Reyes? Mr. Damian, can you please call her name out?
Yes, ma'am. Glenda Reyes. Glenda Reyes.
We have an agreed decree, Your Honor. She signed. I don't think she was going to be logging in.
Okay, and is your client on?
Yes, Your Honor. Mr. Reyes, Omar Reyes.
Do you see him?
Yes, I'm here. I'm here, Your Honor.
Okay, Mr. Reyes, can you turn on your camera, please?
Yes, ma'am.
Okay, so Mr. Cantu, do you have any objection to Mr. Ramirez withdrawing today?
No, Your Honor. No objection.
Okay, Mr. Ramirez, your motion to withdraw is granted, sir, and you are excused unless you
Thank
have
you.
other matters.
No, ma'am. Thank you very much. Thank you.
Okay, Mr. Cantu, we can go ahead and begin the prove up. You said that you have a divorce decree signed by Ms. Reyes?
Yes, Your Honor. We've already filed that with the court.
Okay, Mr. Omar Reyes, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth? So help you God, sir.
Yes, Judge.
Okay, and I need for you to pay attention. I can see that you're driving, so if you can If you
I'm-
find a,
I'm parked.
okay, perfect. Okay, Mr. Cantu, you may proceed with your client.
Yes. Is your name Omar Reyes?
Yes.
Are you presently married to Glenda A. Doster Reyes?
Yes.
Before filing for divorce, had you been living in Texas for the previous 6 months and in
Yes.
Hidalgo County for the previous 90 days?
Yes.
Is there a reasonable expectation of reconciliation with Ms. Reyes?
No reconciliation.
Do you have children married to this marriage?
Yes.
How many children do you have,
I
Mr.
have 2 children, a boy and a girl, Analia Reyes and Omar Alexander Reyes.
Are there any orders currently with any court that are affecting these children, this relationship with the children?
No.
Do the children own property?
No.
Are you asking the court to grant your divorce and the agreements that you entered into with Ms. Glenda A. Doster Reyes?
Yes.
Thank you, Mr. Omar. At this point, we ask the court to grant the divorce and approve the agreement entered into the court.
What's the agreement? He needs to testify to the agreement. What are the terms? Who's staying with the children as far as conservatorship, child support, medical support, division of property? I
Uh,
need him to testify to that.
Okay, Your Honor. Mr. Reyes, have you entered into an agreement as to the division of the property with Ms. Reyes?
Yes, I did.
Have you, do you all have a currently property that needs to be divided with the court?
No.
Okay, as to the possession, do you agree that both of you are gonna be managing conservators with Ms. Glenda A. Doster deciding the primary residence of the children?
Yes.
Do you agree that you're gonna be paying $1,000 of child support for these 2 children until they turn 18 or until this court orders otherwise?
Yes.
And as to the medical insurance, do you have a way of accessing medical health insurance through your job, through your employment?
Yes.
Are you gonna be providing with this insurance to your children?
Miss Glenda and I have agreed on doing it half and half. Yes.
Okay. Anything else that the court needs Mr. Reyes to testify
Yes,
to?
I need to know the step down.
The step down will be once the older child turns 18, Mr. Reyes is gonna be paying $750 for the other child.
Okay,
Yes.
and when Mr. Reyes says half and half, what is that half and half?
Miss Glenda currently has the insurance, and I am giving her the payment that she makes, half of the payment.
Okay, so as additional child support, you're gonna be paying half of the medical insurance premium?
Yes, ma'am.
Okay,
It's on the divorce decree as well, Your Honor.
okay. And you said you had no community property?
That is correct.
Okay. So then each of you will be staying what you have with what the personal possessions you have in your possession, is that correct?
Yes, ma'am.
And will you be further staying with any accounts in any financial institution that are under your sole control and solely under your name? And will she be staying with the financial accounts that are solely under her name and subject to her sole control?
Yes, ma'am.
Okay. Okay, and you did sign the divorce decree?
Yes, ma'am.
Okay, and did you see the signature with your Ms. Reyes's signature on it?
She signed it as well.
Okay, but did you see her signature?
Yes, I did.
Okay, so then that is fine. Then the court will accept the agreement as testified to in the record and will be set forth in more detail in the divorce decree to be e-filed with the court. By when will you be e-filing that?
It's already filed, Your Honor.
Okay, then I'll go ahead and ask for that to be forwarded to my queue. Okay, now was Ms. Reyes asking for a name change? I forgot to ask.
No, Your Honor.
Okay. Okay, then I'll go ahead and have that signed as soon as it's sent into my queue. All right, best of luck to you, Mr. Reyes.
Thank you, Judge. God bless you too.
Likewise. Okay, Attorney Victor Rodriguez.
Morning, Your Honor. I am here on case number CL-21-1721-I. Jacqueline Erasmus is on the other side of that case.
Good morning, Your Honor. Jacqueline Erasmus for Allstate.
We just wanted, we have competing motions, actually not competing motions, but there's a motion, a plea and abatement and also a motion to compel mediation. We've come to an agreement on both of them, Your Honor, and we just wanted to let the court know that we would submit an agreed order later today on covering both motions.
Okay, and that's number 12 on the court's docket. Okay, so then you'll submit an agreed order. Just make sure that both your signatures are on there, please.
Yes, Your Honor.
Yes.
We'll do that.
Okay, as soon as it comes in, I'll get it sent to my queue and then I'll sign off on it.
Thank you very much.
Thank you, Your Honor.
Have a
Anything
nice
else?
day, Judge.
Likewise.
Your Honor, I have one more with you. It's number 9 on the docket. It's Quintanilla v. Allstate. I didn't see anyone from opposing counsel's office. It's just a motion for status of appraisal.
Okay, I think I see, well, Mr. McCallan, are you here on that one?
Yes, Your Honor, I am right
Yes.
here.
I didn't see you, Willie. Sorry.
No problem, no problem. Yes, Your Honor, that case is still in appraisal. We're waiting to see what the conclusion of the appraisal process brings us.
I believe, Your Honor, that plaintiff needs to pay their portion of the umpire fee. That was the only thing pending, so I don't know if Mr. McCallan can check on that.
I'll
and
check
then
on
we
that,
could
Your Honor.
just-
I don't,
yeah.
I didn't, I'll double check and see where we are on that.
Okay, perfect.
Okay, so then how much time do you need?
Um,
I'm
What do
not,
you think,
because I'll
Willie?
need to set you for a status.
Yeah,
I'm not-
maybe a couple of weeks. I'll check on that.
Okay. Then do you need more than August the 16th?
That's
I think
perfect.
that should be fine.
Okay, then come back on August the 16th at 9:30 a.m.
Okay,
Thank
that's
you, Your
all
Honor.
I have, Your Honor. May I be excused?
You certainly may. And
That's
Mr.
Thank
all I
you.
have.
Have a
McCallan,
good day.
Your Honor. May I be excused?
you certainly may.
Thank you, Judge. Have a great day.
Thank you. Okay, Attorney Marco de Luna.
Good morning, Judge.
Good morning, sir.
Judge, I have number 6 on the civil docket. I think Ms. Arispa's on the other side, and I do see her on there.
Okay, F 2527-15-9. I have it styled as in the matter of the marriage of Manuel Salazar and Minerva Maldonado Salazar. And what are the announcements, counselors?
Judge, in this case, Judge, it's always been contested, Judge. I believe Mr. De Luna and I had agreed we were going to exchange exhibits before trial to see what exhibits we would agree to, so we wouldn't delay the hearing, Judge. So we would need probably maybe 2.5 hours, I would imagine, Mr. De Luna.
I would believe so, Judge. And again, just so the court is aware, this is a case that we had for several times, and then before COVID, we had asked for a bench trial, Judge, on the final hearing on it. It wasn't for lack of not wanting to go forward with the case itself. Like I said, the last time, Ms. Arispa is absolutely correct. The last time we had I believe this case was out of, well, I know it was out of county court number 2. They had asked us just to see if we could e-file anything that we were going to be wanting to use for the final hearing. We just need a final hearing date, and we can prepare those documents and have them, I guess, scanned and e-filed with the court. Or I don't know how the court wants to hear it, if it's going to be in person or.
Okay, well, let's take it a step at a time first. Okay, so do these people have children?
They're adults already, Judge, so there are issues on retro child support.
Okay, so then the issue will be on retro support, and what about on property?
There's some property issues also, Judge.
There's
Okay.
property issues also.
And who did you all attend mediation with?
I believe we did mediation with Andrew and Magir, and that was at the beginning of the case, if I'm not mistaken, Judge.
That is correct, Judge.
Okay, well, that's very stale, because that would tell me that you were talking about issues of what, minor children at the
Correct.
time?
That's correct, Judge.
Yes.
Okay, so I'm gonna have y'all I want you to please submit an agreed order for mediation, and I'm going to send y'all back to mediation.
Yes, Judge.
Okay. That agreed order needs to be signed by both of y'all.
Yes, ma'am.
And then if you want a bench trial, that's fine. Just obviously your discovery period has been quite long. And so have y'all already exchanged everything that you needed to during the discovery period?
I believe so, Judge. I really think that it's really it's really going to come down to a retro amount at this point because of the minor. There's no minor children anymore involved in the case, and just a couple property issues. So it's not much. It's not a.
Okay, so we're not going to be arguing about whether discovery period is open or closed.
That's correct, Judge.
That's correct.
Okay, so, all right. Well, it's numbers. And sometimes when you're messing with people's money and stuff, of course, it's going to be sensitive. And that's usually when I found it was more difficult to settle a matter because nobody wants to let go of their money. So take the time and I'll submit that order. I'll assign somebody to mediate the case for you all. And then also I need for you to submit an order for a DCC and we'll get your bench trial set up.
Yes, Your Honor.
Okay?
Yes, ma'am.
All right, so I'll await both of those orders, have them both signed off by both of y'all, and then we can keep you moving on this case.
Yes, ma'am.
Yes.
Thank
Okay?
you. May we be excused, Your Honor?
You certainly may.
Okay, Judge. Thank you, Judge.
Okay, thank you. Attorney Arturo Cantu?
Good morning, Your Honor. I have number 19 on your docket. It's Quiroz versus Garcia. This case was mediated with Bill Garza and it was settled. It was a joint motion to dismiss filed, but I think the problem is, I think you want us to sign the order dismissal too. The motion was signed by both attorneys, but not the order dismissal, but I can circulate the order dismissal to Bobby Garcia, the plaintiff lawyer.
Yes, please. And that's CO 181162-I. That's number 19 on the court's docket. If you can just submit an amended order with your signatures and that'll take care of it.
All right, I'll do that, Your Honor. Thank you. That's all I have before the court. Have a
Okay,
good day.
you may be excused.
Thank you.
Okay, Attorney Claire Portis?
Good morning, Your Honor. I'm here on two cases. First one is number 10 on your docket.
Okay, CO 193806-I, One Main Financial et al. Versus Miguel Esparza.
Yes, Your Honor. And I'm showing that it's set for default today, but I am showing the defendant answered back in 2019.
Okay. And is
So
Miguel
that's-
Esparza on? Mr. Damon, can you call out his name?
Yes, ma'am. Miguel A. Esparza. Miguel Esparza. Miguel Esparza.
Okay, so he filed an answer back in 2019. So what do you want to do?
I mean, I'm ready to proceed, but I think we need to set it for trial.
Okay. So then are you setting that for a bench trial then?
Yes, Your Honor.
Just submit an order for a DCC. And
Thank
give him notice of that. And then we'll give you a date and time and we'll assign a date for you for a bench trial.
Thank you.
Okay, and you have what other case?
Number 11 on the docket, Citibank versus Domingo Caceres.
Okay, CO 194283-I. Okay, and what do you have on that?
Your Honor, we filed a motion for default judgment on May 17th of 2021. We asked the court to allow us to proceed on that motion.
And did Mr. Caceres receive notice of that motion for default judgment?
I am showing that an order setting hearing was sent by first class, and I'm just confirming, Your Honor, but I believe I checked earlier, and yes, they had.
If I may?
Yes.
Yes, ma'am. The order setting hearing does reflect his mailing address.
Okay. And Mr. Damon, can you please call out Mr. Caceres' name 3 times?
Yes, ma'am. Domingo A. Cáceres. Domingo Cáceres. Domingo Cáceres.
Okay, Ms. Portis, the name being called out 3 times. No response, you may proceed.
Mr. Honor, we filed a motion for default judgment on May 17th of 2021. Attached to that motion are business records affidavit, certificate of last known address and military service affidavit and service member information, showing that the defendant has a charge-off balance in the amount of $2,150 on a Citibank NA Best Buy card ending in account number 9920. We ask the court to grant judgment in that amount and also cost of court and post-judgment interest.
The court will take judicial notice of all the documents in the court's file, specifically that defendant failed to answer, and will grant the relief that is requested and as set forth on the record by plaintiff's counsel. Do you have an order on file to that effect?
Yes, Your Honor. I believe a proposed order was attached to the judgment as an exhibit or as an attachment.
Okay. Then I'll ask for that order to be forwarded to me.
Thank you, Your Honor.
Okay. Anything else?
That's all I have for this morning.
You may be excused.
Thank you.
Thank you. Mr. Flores, were you raising your hand?
Yeah, we reached an agreement in ours. And then Mito's online also.
Good morning, Your Honor.
Good morning. Okay, that is F 2783-21-9 in the matter of the marriage of Michael Castillo and Leslie Robles.
Yes, sir, Judge. For the record, Judge Roby Flores from Mr. Michael Castillo.
And Edelmiro Redondo, Your Honor, present for Ms. Leslie Robles. She's present here in my office.
Yeah, and my client's on screen, but he's here in my office.
Okay, and so you're ready to move forward with proving up temporary orders, or did you want to just submit your agreed temporary orders?
Well, let me just put it on the record real quick, Judge. What we're agreeing to do is that the status quo is going to remain. They're both living in the same apartment, and they'll continue doing what they've been doing, sharing the child at that residence. The child won't be relocated from that residence. The parties will continue to reside there. But for the week in July, Judge, Ms. Castillo has made arrangements to go out of town the 12th through the 19th. So she will have possession of the child the 12th through the 19th. He will have possession of the child the 19th through the 26th. There's not going to be any designation of primary at this point. They're just basically both joint. We're agreeing that there's going to be a child custody evaluation. We're agreeing to Gilda Bowen, and that the costs be divided equally between the parties, Your Honor. And then hopefully we'll come back in August. They'll have taken their respective trips, and Ms. Bowen will have 30 days to give us and the court some guidance as to what to do.
Okay, do you have an order on file with Ms. Bowen on there, or you're just about your?
We're going to prepare it right now. I'll forward it to Ademito for his signature, and then we'll file it with the court.
Okay, so then why don't y'all come back? I'm gonna go ahead and set you for a status hearing.
Okay.
And I'll have y'all come back for a status hearing on August the 23rd.
Perfect.
And then if for some reason everything is ready, you can move forward. If not, we'll just keep track.
All right.
Thank you, Your Honor.
Thank you, Judge.
Okay, and Mr. Flores, if you can just touch base with Ms. Klein as to how you all
Yes.
are at for this afternoon.
Yes, Your Honor, I will.
Okay, thank you.
Thank you, Your Honor.
Okay, Attorney Robert Mesa.
Good morning, Judge. We have number 7, Your Honor, on the court's docket this morning.
Okay, F 2673-17-9 in the interest of minor children. And I have Mr. Ball on the other side.
Yes, Your Honor.
Okay, and what are your announcements, counselors?
Judge, on this case, this is we're asking to prove up the order. It's a motion to modify that we had filed. Mr. Ball, I believe his client, I saw her on here as well, Your Honor. It's a signed order and we just need to prove it up, Your Honor. My client is on, Mr. Franco, and so I just need to prove it up with him, Your Honor.
Okay, what are the parties' names?
Sergio Franco is the father or the movement on this case, Your Honor, and then I have Irene Hernandez, but I'm not sure she is under Irene Franco, Judge, which is what I see on the screen.
Okay, so Mr. Sergio Franco, can you hear me?
Yes, ma'am. Good morning, Judge.
Good morning, sir. And Miss Irene Hernandez Franco, can you hear me?
Yes, I'm here.
Okay. Miss Franco, can you turn on your camera, please? Okay. So let me have both of you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Miss Hernandez Franco? You're on mute.
Yes, ma'am.
Okay. All right. Mr. Mesa, you may proceed.
Thank you, Judge. Is your true and correct name Sergio Franco?
Yes, sir.
Mr. Franco, you are the movement on this case. You filed the motion to modify the suit affecting the parent-child relationship, correct? Mr. Franco?
Yes, sir.
Okay, we did file a motion to modify the order, correct?
Yes, sir, we did.
Okay, now there is an agreement between you and Miss Hernandez, Irene Hernandez, regarding the conservatorship of the children, and I'm gonna read it to you and you're gonna answer yes or no to the agreement, okay?
Yes, sir.
Okay, now, both of you are appointed joint managing conservatorship. There are 2 children of this prior marriage, correct?
Correct.
Okay. And as far as your son, which is Sergio Hugo Franco Jr., he will be living with you, correct?
Correct.
James Dylan Franco will remain with his mother, which is Miss Irene Hernandez, correct?
Correct.
And as far as the visitation, you're asking that visitation take place. You will have visitation. Each one of you will stay with one of the children. You will stay with the oldest, Sergio Franco Jr., and then Miss Franco will stay, or Miss Hernandez will stay with the youngest, correct?
Correct.
You will have visitation of both children on the 1st and 3rd weekend of the month. And then Miss Hernandez will have visitation of the children on the 2nd and 4th weekend of the month. And then if there is a 5th weekend in the month, there will be no exchange, correct?
Correct.
Okay. Now, as far as child support, the agreement is that there will be no child support to be ordered beginning, should be July 1st of 2021. And then once the oldest child, which is the child that you have, reaches the age of 18 or graduates, we have already anticipated the date that will happen sometime in July of 2023, and the child support will resume at that point, correct?
Correct.
Okay. Now, you will be paying Ms. Hernandez $600 a month.
Correct.
Okay. And actually, the date of the child support to resume as set out in the order should be November 1st of 2023, correct?
Correct.
Okay. And you will continue to pay all the medical and the dental insurance for both of your children, is that correct?
Correct, sir.
And the total medical you will be paying is $358.54 for health insurance, correct?
Correct.
And the dental will be $57 a month, correct?
Yes, sir. Correct.
Okay. And this is the agreement that you have entered with Mr. Hernandez, and you're asking the court to approve this agreement, correct?
Correct.
That's all I have, Judge. I'll pass the witness to Mr. Ball.
No questions for him, just a couple from my client, Judge.
Okay, you may proceed.
Ms. Hernandez, you read you heard the agreement that was read in the record, correct? Maybe?
You're on mute, Miss Franco. You need to,
Possibly?
Miss Franco, you need to unmute yourself. Miss Franco, can you unmute yourself? Can you hear?
I can barely hear, that's why.
Can you hear me, Ms. Franco?
A little bit.
Did you hear the agreement that was read into the record by opposing counsel?
He was reading. Yes.
Okay, and you and I had an opportunity to discuss the documents that were sent over this morning before the hearing, correct?
Yes.
You're asking the court to approve this agreement?
Yes.
Okay, that's all I have, Judge.
Okay, how old is the oldest child?
The oldest was 16, Judge. Mr. Franco, is he still 16 at this point?
Yes, sir, he is.
And the youngest?
I have him at 6 years of age, Your Honor.
I'm sorry, how old is the youngest child?
The youngest is 7.
Okay. Okay. The splitting up the children is not the most ideal situation. So I do, how close in proximity do you and Mr. Franco live? Do y'all live in the same city or how far away do y'all live?
Probably like 30 minutes away.
Okay. Well, I encourage you all to let the boys see each other as often as possible. They are brothers. You know, I don't like splitting the children, but I also understand that your oldest is 16 and 16-year-olds tend to have a different thinking than a 7-year-old. So, but I'm going to go ahead and approve your agreement as testified to on the record. Will be set forth in further detail. That'll be set forth in further detail in an order to be signed off by the attorneys and the parties. How much time do you need to submit it?
Judge, the order has already been signed off by my client, Ms. Hernandez, and myself. I think it was just waiting Mr. Ball's signature, but it's already been prepared, Your Honor.
Okay, well then as soon as it's submitted to me, then I'll go ahead and have that forwarded to my queue.
Yes, Your Honor.
Okay.
That's all we have. Excused.
Yes, you may,
Thank
Mr.
you.
Ball.
Thank you,
Thank
Judge.
Okay, Attorney Michael Moore. You're on mute.
There we go. Sorry about that, Your Honor.
Okay.
I thought I undid it. We have a quick announcement on Ricardo Reynosa and Elizabeth Tejas as plaintiffs and Alternative Efficient Technologies as et al. As defendant in my opposing counsel. Mr. Truesdale is on here, and we have nothing to announce other than just getting this matter set for DCC.
Okay, and that is CL 173187-I. Okay, so then we're going to be setting this for a jury trial or a bench trial?
It's going to be a jury trial, Your Honor.
Okay. And you said Mr. Truesdale was also on?
Yes.
Yes, ma'am. Good morning.
Good morning, sir. Okay, then what we'll do is we'll have you come back on September the 29th. And by then I should be ready to start scheduling the DCCs for the jury panels.
Is that going to be a status conference like this, Your Honor?
Yes, I have to set it for a status.
Okay.
Okay, so it'll be September 29th at 9:30.
Thank you, Judge. May be excused.
You certainly may.
Thank you, Your Honor.
Okay, Attorney Rogelio Garza.
Good morning, Your Honor.
Good morning, sir.
Number 20 on the court's docket, we're set for a status hearing. I know Ms. Edna Cedillo, the item is on the screen. I did not see defense counsel, but all we need, Your Honor, is a friendly suit hearing.
Oh, okay.
It already settled.
Perfect. Okay, that is CL 194471-I. And how much time do you need? Has everything already been exchanged between the parties?
They have, Ms. Cedillo has received all the information as the item, and she has met with the parent as well.
Okay, so go ahead.
I just said that's correct, Judge. Good morning.
Good morning, ma'am. Okay, then we'll set it for August the 16th at 9:30. That's the earliest I have.
Thank you, Your Honor. That's all we have.
Okay.
May we be excused.
You certainly may. Thank you.
Bye-bye.
Okay, Attorney Nick Moore.
Good morning, Your Honor. I
Good morning,
have
sir.
number 22 on the docket. And I am standing in for Miss Gracie. This is a status hearing, and we also filed an agreed motion to sever and abate the extra contractual claims. I'm not sure if defense counsel is present.
I'm here, Your Honor. Mark Hanna for the defense.
Okay, that is CL 210305-I, number 22 on the court's docket.
Yes, Your
Okay,
Honor.
do y'all have the order on file?
Yes, Your Honor.
Okay. And what else are we doing on this case? I know it's fairly new. Have you all already begun your discovery?
Yes, Your Honor.
That's,
We've ex-
go ahead, sorry.
Sorry, we've exchanged some discovery. We've got maybe one more set to send out and to do a deposition of the plaintiff and possibly the underlying tortfeasor, and then we should be ready to either mediate or start working towards trial.
Okay, and are y'all agreeing to a mediator, or do you need the court to appoint one?
I think we'll be able to agree to one, but
Yeah.
if not, we can always readdress that.
Okay, so then, in how many days are we looking at that you can feasibly go to mediation?
Let me take a look. I'm thinking that depositions will take place at the end, towards the end of July or early August, and then we would probably need another 30 days to get to mediation so that my client, State Farm's a large entity, and they need usually about 30 days to go over our mediating report and stuff. So I would say probably early September or late August.
I'm agreeable to that, Your Honor.
Okay, so why don't y'all come back on October the 4th and let me know where we're at. That should give you plenty of time to get through your discovery and do the mediation and review any, what it is that you will be doing after that.
That's at 9:30, right, Your Honor?
Yes, sir.
That's all I have.
Was that October 4th, Your Honor?
I did.
Okay, thank you, Your Honor.
Thank you, Judge. You have a good day.
Okay, likewise. We'll see you then.
Thank you.
Okay, Attorney Christopher Castillo.
Good morning, Your Honor. Christopher Castillo here for David Flores on cause number F6075199. I don't have the number of the docket, Your Honor. I apologize.
Number 25 on the court's docket, Your Honor.
Thank you. Okay, in the matter of the marriage of Melissa Beckwith and Arthur Beckwith.
That is correct. We're here set for status this morning, Your Honor. I believe discovery is still pending. I believe Ms. Klein has a motion to withdraw on file that has yet to be, ruled on. However, Attorney David Gossel has filed a notice of appearance and shall be, substituting for Ms. Klein. We've been in communication with Mr. Gossel to provide the discovery that's pending. And all we're requesting to see if we can get a DCC setting.
Okay, well, Mr. Cejas, do you know if the order setting hearing has been submitted on your motion to withdraw?
I do not know if the order setting hearing has been set. I know that an order on the motion to withdraw has been sent.
Okay,
My understanding is that it was set. I thought it was set for today as well, along with the status.
okay, and did Mr. Beckwith, did he sign off on the motion to withdraw, or has he had notice?
He does have notice, Your Honor. He does agree with it. As Mr. Castillo said, that Mr. Gossel has already filed a motion to substitute in his counsel.
Okay, then, and Mr. Castillo, you have no objection, obviously, with Mr. Cejas and his firm withdrawing?
That is correct, Your Honor. No objection.
Okay. Then we'll go ahead and have that order forwarded to my queue, and I'll sign off on it.
Thank you, Your Honor. That's all the business I have before this honorable court may be excused.
You certainly may. Okay, and
Thank
is
you, Judge.
anyone here from Mr. Castle's office? Okay, Mr. Castillo, if you can get a hold of Mr. Castle's office, I do need to hear from them.
Okay. I spoke with them this morning. Let me get in contact with them.
Or do you have permission to make the announcement on his behalf as well?
No, I do not. I did not get that permission this morning, Your Honor.
Okay, I'll recall you shortly. Just
All right,
call
thank you.
us. Okay. Mr. Cantu, did you have an additional announcement on another case?
Yes, Your Honor. I didn't know if we were just making announcements, so I didn't want to take up the time, but I do have another uncontested matter. It's divorce.
Okay, and is
It's
that on?
number 23 on your docket in the matter of the marriage between Evelyn Garza and Daniel Robles.
Okay, that's number 4 on the court's docket.
Oh, it's number 4. I'm sorry. The other one was number 3. Yes.
Okay, so that is F 1341-21-9 in the matter of the marriage of Evelyn Garza and Daniel Robles. And who is here on behalf of Mr. Robles?
His pro se, Your Honor. We filed the waiver of service. It's agreed as well.
Okay, and he's already signed off on your divorce decree?
Yes, Your Honor. I think he's logged in.
Okay, Daniel Robles?
Yes, ma'am.
Okay, and Evelyn Garza, is she present?
She should be logged in.
Yes, I
as
am.
well.
I'm right here.
I'm sorry, I didn't get that. Where are you?
Can you hear me?
Okay, now I can. There you go. Okay, so let me have both the parties raise their right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Yes.
Okay, Mr. Cantu, you can proceed with your client.
Yes, Miss Evelyn Garza, just to confirm that you are presently married to Daniel Robles.
Yes, sir.
Before filing of this lawsuit, had you been living in Texas for the preceding 6 months and in Hidalgo County for the past 90 days?
Yes.
Are there any reasonable expectations of reconciliation?
No, not at all.
Are there any children to this marriage born or adopted?
No.
Any child expected at this time?
No.
You and your spouse have entered into an agreement concerning the division of the debts and properties where you agree that you all don't have any community property.
That's correct.
You agree that whatever personal property will be awarded to the party having possession of that property.
Yes.
You agree that you will be responsible for whatever debts and obligations that are currently under your name.
Yes.
Okay, so at this point, you are asking the court to grant your divorce and to approve all the agreements that you've entered into with Mr. Robles.
Yes.
All right, thank you, Your Honor. No further questions for Ms. Evelyn Garza.
Do you have any questions of Mr. Robles?
No, ma'am.
Mr. Robles, did you hear the questions that I asked Ms. Evelyn Garza?
Yes, sir.
Are this is this what you signed off on the agreement?
Yes.
Did you have an opportunity to look over the agreement and see Mrs. Evelyn Garza's signature on that agreement?
Yes.
No further questions, Your Honor.
Okay, so is that divorce decree already on the court's file?
Yes, Your Honor. It's already been filed, signed by both parties.
Okay,
And
the
waiver
court
of
will,
citation as well.
okay, the court will take judicial notice of all the documents in the court's file and also will grant the relief as testified to by the parties and will sign off the divorce decree that is already filed, okay? Mr. Robles, in the future, when you make a court appearance, please wear appropriate attire. Sleeveless shirts are not allowed on camera, okay?
Okay.
Okay, thank you. Best of luck to both of you.
May we be dismissed, Your Honor?
Yes, you may. Mr. Castillo?
Yes, Your Honor. I already spoke with Mr. Caso's office, and they, going back on F-6075-199, number 25 on the docket, I got authority from his office to make the announcement to request a DCC.
Okay, so then are you all setting this for a bench trial or a
It's
jury
actually,
trial?
A jury trial, Your Honor.
So then it's already worked up, all discovery has been exchanged?
Well, discovery is still pending, and that's one issue we spoke with Mr. Gasso about on Friday. He's going to be providing to our office any pending discovery that was requested sometime back.
Okay, have y'all gone to mediation?
No, we are waiting to receive the final discovery to attend mediation.
Okay, so I need for you all to submit an agreed order for mediation, and I'll sign off on that. And I'll assign a mediator to you all to mediate within a certain time period, okay?
Okay, Your Honor.
And then I'm gonna have y'all come back on September the 20th. And it's gonna be for an additional status to see if all of that has already been done.
Okay.
At 9:30 a.m. And then if it has, then we'll proceed forward to giving you a DCC date.
All right, sounds good, Your Honor. Thank you.
Okay, we'll see you at that time.
All right, thank you. May I be excused?
You certainly may.
Thank you.
Okay, and Mr. Gomez, did you have your hand up?
I did, Your Honor, and it's a case that I only got notice of shortly or a short while ago. It's F323514-9. I don't know where it is on the court's docket. I did not get notice from the court. I got notice from the Hidalgo County District Clerk's Office. They send a friendly reminder out to to attorneys about the cases that they have, and that's how I picked up that this case was going to be called today. I don't know if my client has received notice. I see that the notice that the Attorney General's office sent out went out to a P.O. Box 1397 in Progreso, Texas, but I don't know if my client received the notice, and I don't know if he's on right now.
Okay, and
He's not on.
that's number 14 on the court's docket. And do you have opposing counsel?
There was a motion to withdraw, Your Honor, filed by Armando Guerra, who was the last counsel for Ms. Nita Ruth the Garcia, the respondent in this case.
He has since withdrawn, Your Honor.
Okay, so Mr. Guerra withdrew,
That's correct.
and is there an order on file to that effect?
I believe I saw there was an order signed allowing Mr. Guerra to withdraw, Your Honor. Yes.
Okay, and Ms. Garcia, were you going to retain new counsel?
No.
So you're gonna proceed on your own?
Yes.
Okay. And Mr. Gomez, you're saying that you didn't receive notice from our office?
Well, I printed out what I found on Odyssey, and it addresses the Attorney General's office, it addresses Ms. Garcia, and addresses directly, but does not send notice to me. And I did not receive notice of this setting.
Okay, Mr. Alcantara, and you're here on this case as well?
Yes, I'm with the Office of the Attorney General, Your Honor.
Okay.
I did notice that as well, that Mr. Gomez did not receive notice. I'm not sure exactly what happened as to why he wasn't included in the order setting hearing. If he thinks he may need more time to get in contact with Mr. Dunhow to see what may be done on this case, the state would have no objection to resetting.
Yes.
Although in this case, the child is already 18 and has emancipated, which is pending retroactive child support judgment to be taken.
Okay, so what I'm showing is that the order setting hearing that was filed by the Office of the Attorney General's office for some reason didn't include you, Mr. Gomez.
That is correct. It did not include me.
Yeah, so the notice, we only send it out to whomever is on that order. So there must have been an oversight somewhere, but I'll give you all an opportunity to talk. How much additional time do y'all need?
A couple of weeks, Your Honor.
Okay, the earliest setting I have is August 16th.
That would be fine.
Okay, and I seen that this is a hearing on a SAPS, or is it gonna be agreed to?
I have no information other than what my client last told me, and he was a primary custodian at the time.
Okay, Ms. Garcia, since you're representing yourself, can you let the court know, is there an agreement that you and the father of the child are coming into?
Well, my son is 19 years old. He graduated high school on May 27, 2021. he is an adult, so I have no issues with just keeping him as a primary if this case can just finalize, because I can't keep missing work. I work full time.
Well, I'm going to encourage you all to please get this ironed out between you all before then, so that you can get it finalized at the next setting of August the 16th.
Thank you very much, Your Honor.
Okay, so it's August the 16th at 9:30 a.m.
May I be excused, Your Honor?
Yes, you certainly may.
Thank you.
Nothing further either, Your Honor. You all be excused.
Thank you all very much.
Okay, thank you.
Thank you. Thank you, Judge.
Okay, Mr. Flanagan, go ahead.
Good morning, Your Honor. I'm on your docket this morning on number 17.
Okay, CL 172642-I, Nada Hassel versus Valentin Lopez et al. Okay, and who is opposing counsel?
Damon Garcia is present, Your Honor.
Morning, Your Honor.
Okay, good morning. And what is your announcement, counselor?
Your Honor, we were requesting a docket control conference, but we were set for this status conference hearing. This case is ready to be tried. It's been set preferentially several times in the past. It's already been mediated. Mediation resulted in a settlement with the underlying defendant, which was Valentin Lopez. But Farmers Insurance, the underinsured motorist carrier defendant, did not settle. And we've exhausted all opportunity for negotiations. This is a 2015 motor vehicle collision. It's a pretty straightforward case. It would take 2 days or 2.5 days to try.
Okay, Mr. Garcia, any additional announcement?
No, Your Honor. That's correct. We are just looking to try this case.
Okay, so I don't know if you heard when I had announced I should be ready to start giving out the DCC dates and get a better picture as to trial settings on September the 29th. So I'm going to have you come back on September the 29th at 9:30, and then we should be able to give you better direction at that time so you can start getting ready for trial.
Thank you, Judge.
May we be excused?
You certainly may.
Thank you.
Thank you, Judge. Have a good day.
Likewise, attorneys Catherine Perez and Nereida Lopez Singletary.
Los Angeles Jr.
Your Honor, Catherine Bad is present with Kathleen Guerrero, and she's present in my office, Your Honor.
Lopez Singletary on behalf of Mr. Adrian Cardoza. Mr. Adrian Cardoza is logged in, as well as one of my witnesses for this morning, Your Honor.
Okay, that is F 2799-21-9 in the matter of the marriage of Kathleen Guerrero versus Adrian Cardoza. Okay, so have y'all had an opportunity to confer about this case?
Yes, Your Honor, we conferred briefly over the weekend. We did discuss mediating this matter for temporary, Your Honor. We haven't been able to come to an agreement. I know that right now that Mr. Cardoza hasn't been able to see the children. We did make an offer for a couple of days visitation during each week, Your Honor, but we haven't been able to come to an agreement on that. We are requesting that all visits be supervised at this point due to the allegations that were set out in the affidavit, and requesting an extension on the TRO and mediation on this matter for temporary orders.
And Your Honor, in reference to that, we are not in agreement to the extension of the TRO. There is an affidavit. Some of the allegations that are contained are not true or exaggerated. My client, Mr. Cardoza, and his mother, paternal grandmother, were the primary caretakers of these 2 children. Mom works from 8 to 5, and he just graduated for A&M. He was doing the online classes. He's doing an online certification. Him and his mother were the ones taking care of these children. It's been over 3 weeks that the mother removed the children from the house, and he has not been able to see them or have any contact with them. We are concerned as to who is taking care of these children while mother is working, Judge. And there's also some concerns with the mother having these children away from the dad. So we're asking for visits, Judge, on these children. We're not objecting to mediating this case, but we do not want this TRO to be extended, leaving my client with no visits on his children.
Again, Your Honor,
Okay.
we've offered visits. We're not asking for no visits either. We're just asking for them to be supervised, Your Honor.
And Your Honor, Ms. Bettis did message me right now via text that they're offering Monday and Tuesday from 8 to 5. Judge, keep in mind, my client had been the primary caretaker of both of his children at home while mom was working and he was going to school. So he is not a weekends dad and he is not a part-time dad. He was a full-time job with his children. And that's why we're not agreeing to the Monday and Tuesday only from 8 to 5.
And Your Honor, we don't contest the matter that he was taking care of the children. The problem are the things that took place while he was taking care of the children, Your Honor. As set out in there, there were some very dangerous allegations and conditions that occurred. And so we don't contest the fact that he was taking care of the children, and that's part of the reason she had to remove them from the environment.
So, and Judge, on those and that affidavit, Judge, we are requesting for a hearing. She mentions that he is lazy, not working, complaints about taking the child to the doctors. Those allegations do not give rise. They mention about a gun that has been sold for a long time. Those allegations do not rise to the fact to Mr. Cardoza being deprived of his children. The court did sign that affidavit, and we are aware that courts, are always looking for the best interest of the children until we come to court. But those allegations are not only true, Judge, they're being exaggerated. And like I said, the main argument that Miss Catherine messaged me this morning was about some gun that has been sold for a long time.
Okay, normally I would send you all directly to mediation and then have you all come back. However, because this is extenuating circumstances where visitation has been suspended, how much time are you all asking for a hearing?
I have two witnesses, Your Honor, Mr. Cardoza and paternal grandmother. I'm thinking about maybe 2 hours or an hour and a half.
And Your Honor, I would
Okay.
offer at this point, because we were discussing coming to mediation, a few days at least to get my witnesses. I know this was my motion, Your Honor, but based on what we discussed on yesterday, and I've had some issues with my family at home, I'd ask for a little bit of time. Again, we are offering these visits interim. We're not trying to deprive him of the children.
Okay, give me a moment. Let me. Ms. Rivera, do you know if the setting that we have for Wednesday afternoon? Oh, that is going. It's a bench trial that I have, yes.
Yes,
Never mind. Are y'all available tomorrow at 3 p.m.?
Let me double check.
We are, Your Honor.
No.
Yes, Your Honor.
Okay. Then will that give you enough time to go ahead and both of you get your witnesses back in here at 3?
Yes, Your Honor. I'll be prepared at 3 p.m. tomorrow.
Okay.
We'll be ready at 3 p.m. tomorrow.
Okay, so then let's have y'all come back tomorrow at 3 p.m. If by some reason something settles between now and then, let the court know.
Of course. Thank you so much, Your Honor.
Okay.
Your Honor, that's all we have. Can we be excused?
You certainly may.
Thank you.
Thank you, Your Honor.
Okay, Attorney Manny Guerra.
Good morning, Your Honor. I represent Mr. Emmanuel Arias Arcineda. He's, I believe, online. We're here, I believe, on case number 26 to your docket. It's in the interest of Mia Isabella Arias and Emmanuel Arias Jr., the children. And we filed a request for temporary orders and a temporary ex parte restraining order. And Your Honor, we're asking that you take judicial notice of all documents on file. in the service to to the respondent being Miss Oriana.
Okay, so who are the parties in this matter? Who is the petitioner?
Petitioner is Mr. Arias, Emmanuel Arias.
Okay. And the respondent is?
Mr. Emmanuel Arias Arcineda, and her name is Carla Denise Orellana.
Okay. And do you see Miss Oriana on?
I don't know if it's one of the cell phones that says iPhone or not.
I'm here, Your Honor.
Okay. So then both the parties are on. And Miss Oriana, are you going to be retaining counsel?
I'm trying to get representation, yes.
Okay. So then are you requesting time in order to hire someone?
Yes, ma'am.
Okay. So Mr. Guerrero, I know that you wanted to move forward today, but I do need to give her an opportunity to hire someone.
Well, the
However,
problem is, Your Honor, I'm sorry to interrupt, but the problem is that my understanding is that on prior filings, she has left and is nowhere to be found. We did file this temporary restraining order previously, and we're asking that Your Honor make it a permanent injunction against this lady against Miss Oriana, to be made a temporary injunction pending the final hearing. And we're asking, because he's been asking to see the children for a long time and not able to see the children, we're asking that the court implement temporary orders for parents who live more than 100 miles away in the meantime while she gets counsel. So if that's possible, we'd like to do that.
okay, well, okay. So first, how many children are involved in this?
2 children, Your Honor.
Okay. And how old are they?
Your Honor, one was born in 2008 and the other one 2010. So we're looking at 12 years old. And
okay, can one of the parents tell me how old the children are?
Yeah, Isabella Arias is 12 and Emmanuel Arias Jr. is 11 years old.
Okay, so you have 2 children, that one is 12 and one is 11. Miss Oriana, where are you living?
I live in Fort Texas, ma'am.
Okay, and Mr. Arias, where are you living?
South Bend, Indiana.
Okay. And you're asking for what? To see the children for the summer? Your summer visitation?
From the last day of school to a week before school so I can get them ready for school.
Okay, well, you're not going to get all those days. You'll get 42 days as to the family code, as to what you're entitled to, if that's what we go with. But Miss Ariana, why haven't you released the children to him for his 42 days?
Well, because I can't seem to get communicated with him. I tried to have a conversation with that man and it always turns into an argument. So I, out of nowhere, got a bunch of paperwork, a bunch of legal forms that I don't know how to interpret. That's why I'm trying to get representation, because I don't know where he's trying to go with this. He says he wants visitations, but I've never denied him visitations. So
okay, hold on. Mr. Arias, you need to stop making faces, okay? And you need to stop making your little noises and stuff, okay? So what I'm gonna do is I'm gonna recall you all at 11 a.m. and I have some questions from both of you all, okay? So be on standby and just be ready to be called at 11 a.m.
Thank you, ma'am.
Okay, I'll recall you shortly. Okay, Mr. Kosowski?
Morning, Judge. This is on number 21 on your docket, Jeanette Martinez v. Maria Martinez, CL 201834-I. And I believe I've seen Ms. Casso on as well.
Good morning, Your Honor.
Good morning. And what is your announcement?
Judge, unfortunately, we did not resolve the case at mediation. And I heard the court say that we're going to have to circle around in September for trial dates, but that's probably what we need.
Okay. So then, yes, if you'll return on September the 29th, I should have a better understanding at that point as to when we'll be starting with the jury trials.
And will that be in the form of a status hearing or as a DCC, Judge?
Sir, as a form of a status hearing.
Okay, 9:30?
Yes, sir.
Thank you so much, Judge. That's all I have.
Thank you, Your Honor. May I be excused?
Okay. Thank you. You certainly
Thank you.
may. Okay, Attorney Jaime Cavazos.
Good morning, Judge. Jaime Cavazos here on number 16 on your docket.
Okay, that is P0312-20-9, Nicholas Villarreal versus Abraham Dietz.
Good morning, Your Honor. Alex Left on behalf of the state and the applicant, Ms. Villarreal.
And what is the announcement?
Judge, I don't know if you can recall, there is a companion case F4922-199 that was also transferred to this case, but at a different time was transferred, which was a petition for SAPSR. And last time we were here, we haven't been able to find mom. Dad hasn't had any contact with the children, I believe, since September of 2020. And I guess our plan was for her to be here today. And my understanding, I just spoke with the state and they're saying that they haven't been able to get a hold of her again, right?
Your Honor, if I may, I did reach out to Ms. Villarreal. I have not been able to get a hold of her. The state is asking for a reset and an extension on this case so we can try to get a hold of her and send her a letter via mail.
Judge,
Okay.
Judge, but maybe we were here.
Hold on. How long did you all have notice of this hearing, Ms. Huerta?
It was from April of 2021, April 26th. So it's been 2 months, and I believe she recently changed her phone number because we aren't able to reach her via phone. So we are asking for a little leeway so we can send her a letter to inform her.
Okay, and Mr. Cavazos, you were saying?
Judge, I was going to say, I mean, we would not only object, but strongly object, Judge. We've been here numerous times, not only in this court, but in the previous court, Judge. Last time she was here, the court was very specific that she needed to be here present. I did reach out to the state before, I believe it was Friday, just to confirm, and she's still not here. I know there has been some hearings in Nueces County where she has been present, so I know she's been there, but for some reason she's not appearing. My client, again, is present. He's been present at all hearings, and
So
our request would be that.
Why is she doing anything in Nueces County?
There was an investigation, from our understanding, from my client, is there was an investigation from CPS over there, Judge, that was ongoing. I believe it was closed already. And
Judge, and just to clarify for the record, we do not represent her in the capacity of the SAPSR or the divorce proceedings. We only represent her in terms of the protective order application.
Okay.
At this point, we're asking that the protective order be denied, Judge. We've been here numerous occasions.
Okay, I'm looking up your family case, Mr. Cavazos, and the only thing I have is the SAPSR, and then there was an intervention that was filed by the OAG.
Judge, if I may.
And then that's it.
Judge, if I may, we initially filed the petition in 2019. The parties actually reconciled. Not that they were married, but they got back together and they were together throughout the holidays. There was an incident where dad and mom moved. That is when the protective order was filed. We did serve her initially with the original petition. We had not amended the petition. We did file into the protective order for paternity. There were some issues with paternity. So in the protective order, we were able to get an order for DNA. The DNA did come back where we got the results, I believe, in April of this year. And that was the time that it was transferred to your court. I have been trying to, I mean, she was served on the SAPSR. The children, like I said, initially were with dad's care. When we filed, dad had the children. After they got together and they moved in together and she moved out, she took the children, and dad has not been able to see. The oldest child has his name and he's on the birth certificate. The youngest child does not have his name and he's not on the birth certificate, but the DNA has shown that the oldest child, he's not the biological dad, and the youngest child, he is. And that was a delay, Your Honor, that we were trying to ascertain the parental.
And Your Honor, the children are not parties to the protective order. It is only the mother.
Okay. I would like for you to please include in your letter that if she's not present at the next hearing, I will not be granting the protective order. This is the last extension I'm going to grant on this.
Yes, Judge, understood.
Okay.
Thank you.
So then I'll have y'all return on July the 21st at 11.
I'm sorry, Your Honor, at 11?
At 11 a.m.
Okay, Judge.
If for some reason you all get a hold of her before, let me know and I'll move you up. But I'm giving you enough time to send the notice via mail.
Yes, Judge. And will this be a setting for a contested hearing?
Yes.
Yes, Judge. Thank you.
Judge,
okay, so we'll
as far as
back here. Go ahead.
Yeah, Judge, as far as a family case, do you want me to set an order setting hearing for that for the same date? Or
I mean, nothing else is that, I mean, if you're you need to move the family case. So if you want, what is it that you're going to be filing on the family case? A motion for temporary orders or what?
temporary orders, and we want to adjudicate the one of the children, I guess the young child, Bea he's dad, and then the other one, of course, he's not dad.
If you have any motions or anything that needs a setting, you can put the same setting. For July 21st at 11.
Okay. Thank you, Judge Bean. That's all I have. May I be excused?
You certainly may.
Thank you.
Judge, that's all I have as well. May I be excused too?
Yes, you may.
Thank you, Your Honor.
Okay, Attorney Hector Garcia.
Good morning, Your Honor. I was going to say good afternoon, but it's still morning.
Yes, sir.
Been here for a while. I'm here on number 19 on your docket, I believe. It's CL 18-1162I.
Okay, Mr. Cantu made an announcement on that case early on behalf of both of you all, that you all were that you mediated and settled, and that the order granting the motion to dismiss was going to be submitted with the attorney's signatures.
What I have on my notes, and I'm here just for Bobby Garcia, is that the dismissal was filed with the court on June the 14th.
Without attorney signatures, though.
Oh, he was filed without? So then we also have to sign it again, I guess.
Yes, any agreed orders have to have the signatures of all the attorneys of record.
Yeah, no, I know that, Your Honor. The thing is that the notes that we have that Mr. Cantu was no longer on the case, that it was Jim Hunter.
Oh, no, he made the announcement.
So, but okay, well, I just let the staff know that the dismissal has not been signed by the attorneys.
Correct.
Or the one that was filed was not signed by the attorneys.
Correct.
All right, thank you. Have a great day and stay safe out there.
Thank you, likewise.
Don't forget, I can do mediations, arbitrations, whatever.
Oh, yes, sir.
Thank you.
Thank you. Okay, Attorney Rubio Salinas.
Yes, Your Honor.
Okay, that is F 5234-14-9. In the interest of minor children, I have Attorney Amber Rodriguez on the other side.
Yes, Judge.
Good morning, Your Honor. Amber Rodriguez appearing on behalf of petitioner. My client and I are present.
Okay, and what are the announcements?
Judge, this was a status hearing. We already did a staffing. We are continuing to encourage our clients to reach an agreement. If not reach an agreement, we had discussed having a bench trial in August.
Okay, so I had an extensive staffing with Mr. Kennedy and Ms. Rodriguez. And who are the parties?
Mr. John Camacho.
And Patricia
And-
Camacho.
And is Miss Camacho is on. Miss Camacho, can you please turn your camera on? Can you hear me, Miss Camacho? There you go. Okay. So I granted the request of your attorneys where I spoke to them at length about my position with respect to your case and what kind of guidance they were seeking at the time. I suspect that your attorneys have conveyed what I have told them to both of you all. Is that correct, Mr. Salinas and Ms. Rodriguez? Okay.
Yes, Judge.
So what I will say is that take it to heart, okay? So I don't have a problem setting you off for a bench trial. It's always better when you come to agreements between the two of you all, because I don't know your life. And to be honest with you, because I don't know your life, I only go with what's going to be coming up in front of me. If a decision I make disrupts your life, I mean, you're asking me to make the decision. So I'm not going to have an issue doing that. Now, you all know your lives. You all know the lives of your children. You all know what your children like, don't like, their personalities, you know, so that's why I've been giving you all plenty of opportunity for you all to try to see about settling this matter. I don't know what's holding you all back. I don't know why you can't come to an agreement. Could be a lot of things. Obviously, it's disagreement. It could be the fact that personalities are different. It could be a number of factors. But what I will tell you is that it's always best for the parties in a matter to be the ones to make the decision. Because like I said, you know your life. Like I would tell my clients, I practiced family law for almost 20 years. I would always tell them, I have enough drama in my own life that I don't need to take on anyone else's drama. So I don't want to have to make that decision for you all with respect to minor children, but I will if I have to. So I provided much guidance in much detail to both of your attorneys in hopes that they would have an opportunity to convey that to you all. So I gave them some direction. Take what they say very seriously, because I gave it a lot of thought and I dedicated a lot of time to talking to them. I do not take decisions with respect to minor children lightly. Okay, it's a very serious matter. And I ask you all to continue to talk as co-parents, because you're going to be the parents of these children forever and ever, even long after you've even left this earth. You will never stop being their parents. And obviously you're here because you all both love your children very, very much. And times like these are not easy, but I'm giving you an opportunity to talk. So are you asking me to give you a setting for a bench trial at this time, or a setting so you all can do a DCC to get this ready for trial?
I would ask the court for a bench trial in August.
Let me go ahead and get, Mr. Salinas, is that fine with you?
Yes, Judge.
Okay. Let me get my August calendar.
Yes, Judge. Additionally, there is a motion for this case has been pending for 2 years. But there was a motion for judge to confer with children. The previous judge, County Court number 1, had met with Cadence, who is now aged out, but the judge has never met with the 2 twin boys. So we'd ask, if we're not able to reach an agreement, if it's possible for the court to schedule time to speak to the boys before that bench trial so that we're fully ready to go to that bench trial.
Yes, okay. So your bench trial setting will be for August the 25th at 2 p.m. How much time are you needing?
I would say this is going to take half a day.
Okay, then we'll start at 2 p.m. till we finish on Wednesday, August the 25th. File any of your exhibits prior to that date. Have all your witnesses ready to go. Contact my court coordinator and she will schedule a time for me to meet with the children.
Judge, I did want to put on the record that we had advised our client what Mr. Camacho was requesting for the court to visit with the children, and our client was not in agreement simply because she doesn't want to put the children in a position where they're having to choose one parent or another. Judge, she doesn't think it's in their best interest for the court, to visit with them on that.
The children will not choose. I will make that decision. However, I will be the one to speak to the children. If you don't want your children to be a part of this or have me speak to them, then the only way that you're going to avoid it is for you all to come up with an agreement. Other than that, when you don't come up with an agreement without realizing it, unfortunately, you make your children a part of the litigation. It's just the reality of it, okay? And so if you don't want them to be a part of the litigation, the only way to avoid that is to come up with an agreement. So other than that, I will be conferring with them, but I don't make, the children will not be choosing. I just will ask general questions. I will talk to them. Children should never be pitted against one parent or another, never.
I guess the point I'm trying to make, Judge, is that if Mr. Camacho and our client is agreeing to do this, if no pressure be applied to these children prior to coming before the court. That's actually the point I was trying to make, Judge, so that they don't feel like they have to choose one or the other.
Okay, they won't. They won't be choosing.
As long as the parties agree to do that, Judge, not to put any pressure on the children.
There should already be a temporary injunction in place regarding not discussing litigation and no disparaging remarks.
Okay.
Is there an order already on file signed by the court?
Yes, I believe so. I'll have to dig my file, but I believe there is already a temporary order in place. Yes.
Okay. So then the outstanding issue then for the bench trial is going to be conservatorship.
Yes, Judge.
And the remaining children are how old?
They're both 10. Is that correct?
Yes, ma'am.
And right now the visitation schedule is what?
My client has a quasi extended standard. He does not, he returns on Sunday instead of Monday.
Okay.
And there is a social, a child custody evaluation in the court's file as well, court appointed.
Okay. Okay, just contact my court coordinator, Ms. Rivera, will get with me about my schedule and we'll make an appointment for the children to be made available to me for me to speak with them. And
Great, Judge.
It'll probably be in the lawyer's lounge, just to be a little bit more comfortable at the courthouse, okay?
Yes, Judge, got it.
And the only people that'll be present is myself and the court coordinator and the children, okay?
Yes, Judge.
Do you all have an ad litem on this case?
We do not.
Okay, you will. So do you want to, you all can talk whether you want an amicus or a guardian?
Yes, Judge, we
I'll give
will.
you an opportunity.
I'll discuss
I'll
that
give
with
you an
Mr.
opportunity.
Kennedy.
Okay. Confer with opposing counsel as to what you all would like. Submit an order signed by both attorneys by tomorrow at 5 p.m. as to which you prefer, a guardian or an amicus. I'll assign someone and that person needs to get working on the case because we will hear it on the 25th.
I understand, Judge.
Okay.
We're still going to hold out on an agreement. We're still hoping.
I encourage you all to come up with some type of an agreement. Okay.
Okay. That's all I have, Judge.
Okay. And these are twins?
Yes.
All right. Well, twins are certainly special. And so you should know your boys. And I encourage you. And let me tell you, I also encourage parents, especially if they live in close proximity, should have as much time as possible sharing the children as their schedules permit. So be honest with one another as to how much time you have to share these children. And I go back to the same thing. If this year has taught you anything, it should teach you what's important in life. Life is very precious. We're here today and we don't know for how long. So either you spend your time fighting with one another or you spend your time enjoying your children. Very simple to me. Okay, very simple. So y'all continue to talk. I'll see you all August the 25th and we'll make the arrangements to see the children soon. Okay.
Thank you, Judge.
Okay, all the parties are dismissed. The attorneys, do you have anything else on any other case?
No, Judge.
No, Your Honor.
Okay, Mr. Salinas pop in once in a while. I only see Mr. Kennedy.
Yeah, sounds good, Judge. Good to see you.
I know you're busy.
Yeah, thank you, Judge. Good to see you again.
Okay, we'll see you all. Take care.
Take care.
Okay. Now, Tracy Dominguez on the screen. Who are you here on?
Myself and Juan Dominguez.
Okay, what's the name of the case?
It's F248320-9.
Oh, okay, I have it as in the matter of the marriage of Juan Dominguez and Tracy Lyons?
Yes.
Oh, okay. And both of you are there on the screen together?
Yes.
Okay, and you're moving forward with a divorce today?
Yes.
Okay. Well, I commend you being very friendly. Okay, let me go ahead and pull up your I'll have your divorce decree already on file?
Yes.
And it was signed off by both of you?
Yes.
Okay, one moment. Okay, so I'm going to call F2483-20-9 in the matter of the marriage of Juan Carlos Dominguez versus Tracy Lyons. That is number 5 on the court's docket. Let the record reflect that both parties are pro se. Both parties are also present, and they do have a final decree of divorce on file. Let me go ahead and check that. Okay, so you all do not have any minor children, is that correct?
Correct.
Okay. Okay, both of you please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Mr. Dominguez.
Yes.
Ms. Lyons.
Yes.
You may lower your hand. Okay, Mr. Juan Carlos Dominguez, you are the petitioner in this matter, is that correct?
Yes.
And you are currently married to Tracy Ann Lyons, is that correct?
Yes.
At the time that you filed for divorce, you had been a domiciliary for Texas, in Texas for at least 6 months and a resident of Hidalgo County at least 90 days.
Yes.
And you were married on or about July 3rd, 2010, and you ceased to live together as husband and wife on June 17, 2020. Is that correct, sir?
Yes, ma'am.
And you're asking for a divorce today, sir, because your marriage has become insupportable because of discord or conflict of personalities between yourself and Miss Lyons. Is that correct?
Yes, ma'am.
And are you stating to the court that this destroys the legitimate ends of the marriage relationship?
Yes, ma'am.
At this time, is there any reasonable expectation for reconciliation, sir?
No, ma'am.
And at this time, are you all expecting any children?
No. No, ma'am.
Okay, go ahead and let Mr. Dominguez answer. I'll ask you right now. If not, we're not gonna have a clear record.
No, ma'am.
Okay. And was any child born or adopted in this marriage?
No, ma'am.
And is there any community property for division in this marriage?
No, ma'am.
Okay. And sir, you have submitted a final decree of divorce, is that correct?
Yes, ma'am.
And in that decree of divorce, and that contains your signature, is that correct?
Yes, ma'am.
And are you asking the court to accept this decree of final decree of divorce and sign it?
Yes, ma'am.
Are you asking the court to accept the agreement as testified by you, Mr. Dominguez?
Yes, ma'am.
Ms. Lyons, you've heard the testimony of Mr. Dominguez, is that correct?
Correct.
And is that your signature on the final decree of divorce that has been filed with the court?
Yes.
Okay. And it is your agreement that there is no community property?
Correct.
Okay. Now, you don't have a counter petition for divorce on file, but are you asking for a name? Is your name staying in Lyons?
I'm gonna stay with Dominguez.
Okay.
Tracy Dominguez.
Okay, I see. No name change. Okay. Okay. Okay, the court will accept the testimony as testified to on the record and will sign the divorce decree. I'll ask for that to be submitted to my queue. Okay.
Okay.
Okay. Best of luck to both of y'all, and I do commend you on appearing together. I know it's very difficult, and I do hope that both of you have a very blessed future.
Thank you.
Okay. All right. You're dismissed.
Thank you.
Thank you. Okay. Let me see. This matter number 15, you said?
Yes, thank you, Your Honor.
It is CL 193838-I, Geico County Insurance versus Sandra Belaguirre et al. Okay. And Ms. Matter, you're here on behalf of Geico?
Yes. And this hearing is just in reference to Susan Galvan. I'm not sure if she's here. I don't believe she is.
I'm sorry, I didn't get that. This is as to who?
Susan Galvan.
Oh, Susan Galvan Olvera?
Yes.
Okay. Mr. Damien, can you please call out Susan Galvan Olvera's name 3 times?
Yes, ma'am. Susan Galvan Olvera. Susan Olvera. Susan Olvera.
Okay, Ms. Matter, you can go ahead and proceed on your motion for default.
Thank you, Your Honor. This has been pending for quite some time. The underlying suit, Geico versus Ms. Galvan, was served on her on September 28th of 2019. And this motion for default judgment was filed, and a copy was certified mailed to her on April 27th of 2020. And as of today, I'm unaware of any answer or response that has been filed by Ms. Galvan Olvera. So we are moving for a default judgment in the amount of $34,899.91, including post-judgment interest and attorney's fees.
Okay, the court will take judicial notice of all the documents in the court's file. In the order that has been submitted to the court, is that the relief that you're requesting today?
Yes, Your Honor.
Okay, so that's on file with the court?
Yes, I believe the order is on file as well for you to sign.
For summary judgment.
The summary judgment is against the other defendant.
Okay. No, I found it. It was filed back on April the 27th, 2020. I'll go ahead and ask that to be forwarded to my queue, and I'll sign off on that. Okay.
Thank you, Your Honor.
Anything else?
That is all I have for you.
Okay, thank you.
May I be excused?
You certainly may.
Thank you. Have a great day.
Thank you, likewise. Okay,
Bye-bye.
Ms. Evangelina Villarreal, you're on F0654-21-9 in the matter of the marriage of Evangelina M. Villarreal versus Jose Villarreal.
Yes.
Okay, was Mr. Villarreal going to be present today?
No, he's not.
Okay, and you filed this divorce pro se?
Yes.
Okay, give me one moment.
Okay.
Okay, so I do see that you have a divorce decree that has been filed and signed by your husband.
Yes,
Okay,
ma'am.
Ms. Villarreal, please raise your right hand. Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Okay, you may lower your hand. You are currently married to Jose Guadalupe Villarreal, is that correct?
Yes.
And at the time that you filed, you had been a domiciliary of Texas for at least 6 months and a resident of Hidalgo County for at least 90 days. Is that correct, ma'am?
Yes, ma'am.
Okay, you were married on or about June 17th, 1978, and you ceased to live together as husband and wife on or about August in 2007. Is that correct?
Yes, ma'am.
And you're asking for a divorce today because you state that your marriage has become insupportable because of discord or conflict of personalities between yourself and your husband that destroys the legitimate ends of the marriage relationship. Is that correct?
Yes, ma'am.
At this time, is there any reasonable expectation of reconciliation?
No, Your Honor.
Okay, ma'am, did you and your husband have any children of this marriage?
We did. We have 3, but they're over 18. The youngest one is 31, so.
Okay, so they're all adults.
Yes, ma'am.
Okay, and you're not expecting at this time?
Oh, no, ma'am.
Okay, and so you and your husband have entered into an agreement today, is that correct?
Yes, Your Honor.
And you submitted a agreed final decree of divorce for the court's review, is that correct?
Yes.
You filed a decree of divorce?
Yes.
Okay. And in that, you're stating that your husband is to stay with any personal effects in his possession. Any sums of cash in his possession are subject to his sole control. Is that correct?
Yes, Your Honor.
And you're also stating that you will stay with any household furniture fixtures that are in your possession, also with any clothing, jewelry, personal effects in your possession, any
Yes,
sums
Your
of
Honor.
now, any sums of cash in your possession are subject to your sole control. Is that correct?
Yes, Your Honor.
Okay, so I'm going to tell you that you have a typo in your divorce decree. And it states that you put husband instead of wife. I want you to know that I'm going to strike that out and I'm going to correct it for you, okay?
Okay, thank you.
And you're also stating that you and your husband have agreed that you will stay with 100% of the interest in the home at 2807 Vista del Viento, Viento Street in Mission, Texas. Is that correct?
Yes, Your Honor.
And you will be responsible for any debts solely incurred by you from August 1st, 2007 forward. Is that correct?
Yes, Your Honor.
Okay. You also have a typo there, so I'm going to change that from husband to wife, okay?
Okay, thank you. Sorry.
And also, you have not put anything that your husband is responsible for any debts under his name from August 1st, 2007 forward. Does he have any debts that he incurred from August 1st, 2007 forward?
Not that I know. No.
Okay. So we're just going to deal with yours. Is that correct?
I couldn't hear you.
We're only going to deal with your debt?
Yes, ma'am.
Okay. So you're asking the court for a divorce today?
Yes.
And that is your husband's signature on the last page of the divorce decree. Is that correct?
Yes, Your Honor.
Okay. Then the court will grant your divorce today, and I'll ask for that divorce decree that was filed on June 14, 2021 to be forwarded to my queue for my signature.
Thank you so much, Your Honor.
Okay. Thank you, ma'am.
Thank you. Have a very nice day. Thank you. Bye-bye.
Okay, I have Claudia Cavazos on, CL 163187-I, Hilda Cano versus Claudia Cavazos. Ms. Cavazos, can you hear me?
Yes, ma'am.
Okay.
Yes, I can hear you.
Okay. Do I have anybody here on behalf of Hilda Cano? Is Hilda Cano on? Is anyone here from Attorney Greg Lopez's office? Ms. Cavazos, you are set for this case to be dismissed today against you. Do you have any objection to this case being dismissed, ma'am?
No, ma'am.
Okay. This case will be dismissed for want of prosecution. Okay, Ms. Cavazos, you are excused.
Thank you so much.
Okay. And Santos Aguirre Campos, what case are you all here on? Santos Aguirre Campos?
Sí.
Okay. Tell her that she's getting an echo. Is she on two devices, Ms. Castañeda?
Ms. Campos está en dos teléfonos porque estamos agarrando un eco.
Ahí. Sí, ya estoy en el teléfono.
Okay, ask her if Pedro Aguirre Moncada will be present today.
Ms. Campos, ¿el señor Pedro Aguirre Moncada va a estar presente?
No, no.
Ms. Campos, ¿me escucha?
No, él no va a estar presente.
No, he's not going to be present.
Okay, ask her if he still lives at 3902 Myra Drive, Mission, Texas, 78574.
Todavía vive en 3902 Street, en Mission, Texas, 78574.
Yo sí.
El señor.
No, él no vive aquí.
No, he does not live there.
She has to provide an address where he lives because she asked that this order setting hearing be sent to her address with his name on it.
Ms. Campos, la orden que usted metió en la corte puso su dirección. Necesitamos una dirección para el señor, porque la dirección que está en la orden es su dirección.
Es que yo no sé dónde él vive.
It's because I don't know where he lives.
Okay. He filed an answer. Who filed that answer on his behalf?
¿Quién metió la respuesta en, por parte del señor Moncada?
Mire, nosotros agarramos los papeles y él los firmó.
We got some papers and he signed them.
Okay, the address on there has 3902 Myra Drive. Was he living there at the time that he filed this answer?
La dirección que está en la respuesta es 3902 Myra Drive. ¿Estaba viviendo él en esa dirección cuando metió la respuesta?
Ya él casi no estaba aquí en la casa cuando pusimos la dirección esa.
He was hardly ever here when we put that address.
Él nomás venía de vez en cuando.
He would come every once in a while.
Does she know if his phone number is still 956-414-1678?
¿Sabe si el número de teléfono es el 956-414-1678?
Ese es el mío.
That's mine.
Okay. Well, she needs to, because this does involve a minor child, she needs to get some contact information for him or file the appropriate paperwork.
Porque este divorcio sí involucra un niño menor de edad. Necesita agarrar una dirección o meter sus documentos apropiados para la corte.
Mi hija tiene el teléfono de él.
My daughter has his phone number.
Well, then I suggest she contact him to get a phone number where he can have an order setting hearing sent to him.
Le voy a pedir que le hable para agarrar una dirección para que se le mande a él el aviso.
Es que nosotros le avisamos de esta corte y él dijo que él no iba a estar presente, que por eso él me había firmado los papeles.
We let him know of this hearing and he said he was going to be present and that's why he signed the documents.
He needs to, let me see. Well, I don't have a final decree of divorce signed by him.
Tengo un decreto del divorcio firmado por él.
No, I don't.
No tengo un decreto de divorcio firmado por él.
Pues no sé, pues es como él.
So either she hasn't signed a divorce decree or he needs to provide her an address so I have proof that the order setting final hearing was sent to him.
Me pone un decreto firmado por él o pone una orden para mandarle avisar de la cita.
Es que él sí supo de esta cita y él también me firmó los papeles.
Where is the divorce decree? Oh, on 1013. Okay, hold on. Okay. I do see the divorce decree that she filed. It does have a signature.
Sí, miro un decreto que se firmó por el señor.
No escuché bien.
Sí, miro un decreto que se firmó por el señor.
Sí, él lo firmó.
Yes, he signed it.
How old is her son?
¿Cuántos años tiene su hijo?
Él tiene 17, en enero cumple los 18.
He's 17, he'll be 18 in January.
She did not fill out the conservatorship part of the decree.
No llenó la parte del conservador en el decreto.
She asked for sole managing conservatorship, and unless she's going to prove up with testimony why she should, it should be joint managing.
Usted puso ser la única conservadora de su hijo y solamente que va a poner usted testimonio de por qué debe de ser en custodia junta.
She also didn't put how much child support.
Tampoco no puso cuánto se va a pagar en child support.
Es que yo no le voy a pedir child support.
I'm not going to be asking for child support.
The child is on Medicaid, so she will have to
Medicaid.
ask for child support.
El niño está en Medicaid, so tiene que pedir child support.
And he has to also reimburse the state for the Medicaid amount.
Y también tiene que regresarle para atrás al estado lo del Medicaid.
Como él tiene que pagar lo del Medicaid.
So he has to pay the Medicaid?
Yes, he has to pay the state an amount to reimburse for Medicaid.
Sí, tiene que pagarle al estado una cantidad por el Medicaid.
Okay.
Okay.
So, and she also was supposed to notify the Attorney General's office to see if they wanted to file an intervention.
Y también tenía que haber notificado al departamento de child support a ver si van a meter una intervención.
Because the child is on Medicaid.
Porque el niño está en Medicaid.
So she needs to update her decree and refile it.
No, necesita corregir su decreto y volverlo a meter con la corte.
Yo quería avisarles que no sé cómo, si me van a poner la cita otra vez o para llevar los papeles. Es que no, yo voy a salir a los trabajos.
I don't know what you want me to do because I'm going to leave to out of state.
I can't tell her what to do because I can't advise her. The only thing I can tell her is that her decree is incorrect and I cannot sign it.
No puedo darle ningún consejo. Lo único que le digo es que su decreto está incorrecto y no lo puedo firmar.
Okay.
Okay.
So, I mean, I'll give her some time. If she updates it, she has to do it by August the 25th at 9:30.
Le voy a dar hasta agosto 25 a las 9:30 para que lo corrija.
And she can come back at that time.
Y puede regresar a esa hora.
Okay.
Okay, then we'll see her then.
La miramos entonces.
Okay, gracias.
Okay, thank you.
Okay, F3984-20-9 in the matter of the marriage of Jesus Lopez Garcia and Maritza Garcia James. Is anyone here for that? Okay, that'll be dismissed for want of prosecution. Okay, so let me recall. F 2256-21-9 in the interest of a minor child. And Miss Oriana, are you still on?
Yes, ma'am.
Okay, let me have both of you raise your hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
Okay, so then, let me, so right now, Mr. Guerra, what your client is trying to do is to at least get his summer visitation so he can see his children. Is that correct?
That's correct, Your Honor. And also to have, daily contact from 5 to 6 or 6 to 7 by social media or by FaceTime.
Okay, and Mr. Arias, when is the last time that you saw your children?
I FaceTime with my son yesterday, but before that it had been November.
Okay.
And I haven't physically seen him since 2019, 2018.
Okay, so you haven't physically seen him since 2019?
No, ma'am.
Okay. And that's both children or one child?
Both.
Okay. Okay, and Miss Oriana, do you have a problem with Mr. Arias visiting with the children?
No, I do not.
Oh, wow, you have really bad connection.
Can you hear me?
Okay, let's try that again. I can. So Miss Oriana, do you have an issue with Mr. Arias visiting with his children?
No, ma'am, I do not.
Okay. So Mr. Arias, how are you proposing that you pick up your children for your 42 days in the summer?
They can put them on an airplane. They have unaccompanied child services. We did it when I was a child for a long time. My nieces and nephews, we do it all the time. We send kids to see their parents in California, Arizona.
Okay, hold on. Just answer my question. Don't add anything more to it, nothing less. Just answer the question, okay? So it would be by airplane?
Yes, ma'am.
Okay. And you do know that you're responsible for paying that airfare?
It was agreed that we would go halfway.
Where is that agreed to? Is that an order?
We filed it, I believe.
Your Honor, we made that request. We made that request. We don't know if it was agreed to.
Yeah.
But the request was made.
Okay. But is there an order currently in place that states that?
No, Your Honor.
Okay.
This is the first.
Was there ever a geographical? Hold on. Was there ever a geographical restriction on the children that was violated?
No, ma'am.
Okay.
Everything's been agreed verbally with Miss Orellana, but it's never came to fruition due to monetary problems or whatever.
If the children are going to go visit dad, Mr. Guerra, that's going to be at the expense of the father. So he can make arrangements to have the plane tickets purchased for the children so that they can go and visit him for his 42 days. I know that you're running short on time because school down here starts approximately on August the 16th. So
I'm aware
he's
of that,
entitled
ma'am.
to.
However, I've
He's
done that
entitled
before.
to about.
I have in the past sent money for them to buy them.
I'm talking. Hold on. So he is entitled to it's approximately 6 weeks. So he would need to get this done pretty quickly so he can start at least by July 1st and have them back here approximately like August the 12th or so.
May I, Your Honor?
Yes.
The communications between them have been very spotty. I know that when we have tried to contact Ms. Orellana, the phone constantly goes to voicemail. There's no answering of it, but that's not to say that she doesn't answer. I'm just saying we've had a very difficult time, and it's hard to communicate with regarding these matters when folks are not answering their phones. So that's one issue that I wanted to inform the court about. The other
May I
is,
respond to that, Your Honor?
No, hold on, he's talking. You will have an opportunity. One moment. Go on, Mr. Guerra.
the other is, Your Honor, these folks are going to be needing to communicate and to get along in the future. I'd ask the court to admonish them on those issues, because it's all for the purpose of benefiting the kids, for the kids to grow without any type of friction. And it should be for the benefit of the kids, and therefore the communication should be clear. And they're going to be needing each other's approval and agreement living so far away in the future. So it would benefit them to try to get along for the sake of the kids on these matters. We are asking for that it be a permanent injunction, or a temporary permanent injunction during the pendency of this case, that the children remain in Hidalgo County. And we are asking for a standard visitation, but over 100 miles. And of course, primarily with the visitation taking place in the summer months, just like Your Honor ordered, as well as perhaps any Christmas vacation or other holidays. We're asking that if Mr. Arias wants to come down and visit the kids, a certain time of the month or whatever, that he be able to call her, and that communication be made no later than 3 days prior, and that they be able to come to some agreement for the weekend or what have you, if that's to take place. I know it becomes very difficult for it to be the first, third, and fifth weekends, but again, they need to get along and be able to agree on some of these matters.
Okay, so, and you, Ms. Oriana, I'm not gonna get into a he said, she said about communication and whether you answered, didn't answer. There's a lot, we'll never finish, okay?
Right.
But, and I'm sensing frustration from both parts, and that's natural, okay? So we're gonna worry about what are we gonna do from today forward. So now, communication between the two of y'all has to be just about the children, not about what are you doing, why did you do this to me together, nothing like that. It's just about the kids, okay? So do your children have a device, Miss Oriana, such as their own cell phone or their own iPad?
They did not, they do now.
Okay, so do both children have a phone?
Yes.
Okay, so then I'm not gonna ask you to put that phone number on YouTube, because right now we're on YouTube, so I don't want that public. However, because you are currently representing yourself, as soon as we conclude this hearing, I need for you to please contact Mr. Guerra's office. And I need for you to please give Mr. Guerra the phone number for both of your sons, okay?
Okay. It's a son and daughter.
Okay, a son and daughter, I'm sorry. Okay, so then Mr. Arias will be able to contact the children directly. Now, Mr. Arias, I'm gonna tell you right now the parameters of, it's not to question children as to where's mom, what's going on, or anything. It's just, hey, baby, how are you doing? How's everything going? You know, daddy loves you. Hold on. Things like that. Just very positive and uplifting, okay? Now, it may turn into a serious conversation depending on how their day is going or what's happening, but you need to let that come from the children. You do not try to drag anything out of the children, okay? Okay, hold on. We're gonna get to that, okay. So Ms. Oriana has already stated that she does not have an issue with you visiting with your children, which would lead me to believe then that a standard visitation order will probably be where you end up with, especially because you live more than 100 miles apart, okay?
Yes, ma'am.
Now, the family code does not state that you all have to divide travel expenses or anything of that nature? Because
I'm aware of that, ma'am.
okay.
If I'm to speak to that point right there, there has been in years before, I have told her and I've sent her money, but right at the last second, she changes her mind and she's not sending them. Okay. Another thing is, she gets a job, she gets involved with somebody and leaves the household. And I have no communication with my kids because they are told not to tell me that mom doesn't live there anymore. Another issue I've had, and this has been going on forever, is the fact that my daughter's had her own cell phone and iPad since she was 7 years old. The minute things are going rough over there, or the minute she leaves the household to go live with whoever she's involved at the moment, they take it away from her, or they use any excuse to not let her use her phone. Okay. Mia has had her own cell phone since she was 7.
Okay,
so
hold on. We're gonna stop right there. All right. So the thing is like, look, you all have had an opportunity to hear me already with the other parents. And I'm not, and yes, you bring up some concerns, and I'm sure Miss Oriana, by her facial expressions, has her own concerns, okay? And if necessary, we're going to have an opportunity to give both of you all time to bring those out. Right now, we have to take up the issue that is pressing at the moment, okay?
Yes, ma'am.
You wanted
contact. That's why I opened the case back in April.
Okay, hold on. You wanted to communicate with your children? Okay, Miss Oriana is going to send that information to Mr. Guerra. All right. Communication with the children is about the children and for the children, okay? Not about what's going on with Miss Oriana or anything like that, at least until she gets counsel. Once she gets counsel, then those are issues that perhaps the attorneys can take up.
If I may speak to that?
No, hold on. What you need to do right now is figure out how you're going to fly your children up to Indiana to visit you. For this time, maybe you will not be able to have 42 days because of the sake of the ticket, but you know, the sooner that you get it, the better, because the children do have to, by the family code at the very least, be back 1 week before school starts. Okay, so Miss Oriana, I'm going to ask you, what school district do your children attend at this time, ma'am?
They go to FAR, Idea Academy. So
okay,
it's Idea Public Schools.
Okay, ma'am. Do you know when FAR Idea Public Schools is going to resume for the fall 2021 semester?
Yes, it's the second week of August. I don't have the exact date. I don't remember.
I do, ma'am.
Okay, and what is the date that you have Mr. Arias as your children returning for the fall?
August 12th.
Okay, so then your children need to be back in Hidalgo County with their mother by August the 5th. Okay?
Yeah, I understand that, yeah.
Okay, so you're gonna have an opportunity to check flights and to send that to Miss Oriana so that they can be on there. Yes, sir.
I've done all of that. All that research is done.
Okay.
So that's,
what are the dates that you are looking at to have your children fly out?
I could have them here Friday.
Okay. So then you're stating from the children will be flying out on July the 2nd and will return on August the 5th. Is that correct?
Yes, I can make that happen, yes.
Okay. Miss Oriana, did you hear that?
Yes, I did.
Okay. I know obviously you're not here at this point because you guys have gotten along for all this time. Okay, so this is going to be difficult. These next few weeks are going to be difficult. Okay, now, Mr. Arias, you have to also understand that Miss Oriana is going to have access telephonically to her children while they are in your possession, okay? So to make this easy for this time, not forever and ever, you're asking to have contact with the children when they're not in your possession, Mr. Arias, from 5 p.m. to 6 p.m. Central Standard Time. Is that correct?
At the time when I ordered it, yes, I was working night shift, but now things have changed. Okay, I get off work at 2 o'clock in the afternoon, which would be around 1 o'clock your time.
Okay.
And I am constantly texting and calling my kids, so I really couldn't tell you. You know what I mean?
So then is 5 p.m. to 6 p.m. still gonna work?
Yes.
Okay. So from 5 p.m. to 6 p.m. Central Standard Time, you will have access to speak to your children. Do not think that you're gonna have them on for the hour, okay? Now, I'm not gonna set it, it's not for you to call to be on the phone with them for a whole hour.
I know. Sometimes we talk for 10, 15 minutes, or they got stuff to do, or like on Sundays they go to church, you know. Like I know my kid's schedule, like you know what I'm saying? Like that's taken care of.
Okay, so Miss Oriana will have the same time, but you're on Eastern Standard Time or
Yes, ma'am.
okay. So then that would be that she would be having access to them. So Miss Oriana, from 5 p.m. to 6 p.m. Central Standard Time would be 4 p.m. to 5 p.m. Eastern Standard Time, okay?
Yes, ma'am.
Okay, so you will have the same access to your children while they are in Indiana. Do you understand that?
Yes.
Okay. So if you, and this goes to both of you, when you FaceTime with your children, it's for your children, not show me where you're at, look at what is daddy doing or what is mommy doing or none of that stuff, okay? You're just gonna be talking with the kiddos, okay? And no talking bad about one another and nothing like that. It's just, how are you doing? You having fun? How's it going? Okay. And you're just pretty much catching up with them just to make sure that they're okay. And that's it. Okay?
Yes. The issue comes from the older one. She's going through the whole teenage thing, so she wants to talk about the problems that's going on over there.
Okay.
I don't know what to do after that. Like I don't know what to tell her.
The thing is like, look, that's gonna be hard because
It's super hard.
I'm sure that she opens up to mom about other stuff too. So it's gonna be both ways. And children, you know, they just need to feel that you love them, because you never need to put them in a position where they have to choose, or don't be telling mom this, or don't be telling dad this, or anything like that, because your kids, trust me, I've been doing this for 20 years. If a child may tell you one thing and is going to tell the other parent another thing, it's very common, very, very common.
I've always tried to get Mia to talk to her mom at the same time. I tried to have us both talk to her, but it didn't work out.
Well, you're saying it doesn't work out, and Miss Oriana saying it does work out, because if I have Miss Oriana talk, she's gonna probably say that they're very.
But Miss Oriana may or may not be there at the time.
So that's why I'm saying it's like the children are gonna do. They're young.
I know my son is still like, he's my son. We talk about everything except for mom, and my daughter wants to talk about everything else, nothing but mom.
Mr. Arias, you're going to have a chance to talk at some point. Please allow the judge to finish.
Yeah, I'm sorry.
Okay.
I'm sorry.
Just relax and let her finish.
I'm being extremely patient, but you both need to understand that your kids love both of you, okay? And children are going to go through ups and downs, and their personalities are going to change, and they're going to hit different stages in life. Right now, I'm not going to hear any testimony as to whether one is better than the other, because honestly, like, it's not about that. Right now, Miss Oriana has already stated that she doesn't have an issue with the kids seeing you. And Mr. Arias, you have to acknowledge that's huge, okay? Now, hold on, don't. Miss Oriana is understanding there is no pulling the plug at the last minute. There is no, oh, now she's throwing a tantrum or he's throwing a tantrum. I'm going to make it clear to both of y'all. Your kids don't have a vote in visits. They don't. It's the code says that they visit until they graduate from high school. That's just the way that it is. Okay?
Thank you.
So if the kiddos are having a hard time, I encourage you, Miss Oriana, to talk to them and tell them that You
It's
know,
the law.
although this is kind of unexpected, they're going to be going for, you know, the next 4 weeks to visit their dad. And I know it's going to be hard on you. And I know it's going to be hard on the kids because it's a different change that you all are not used to right now. Okay. I know it's difficult because of the things that you all have gone through in the past, but you all have to give each other some grace, okay? And have some understanding with one another and with respect to the situation. So, Mr. Arias, if you're getting these plane tickets, if there's any information that you are lacking in order for you to get those plane tickets, you need to communicate that with your attorney so that when Miss Oriana contacts him with the phone numbers, he can ask her for that missing information. Okay? Yes or no? You understand?
Yes, ma'am. Yes, ma'am. I have no problem going through my attorney.
Okay. So, Miss Oriana, do you have an email address, ma'am, that you receive emails at?
Yes, I do.
And what is that email address?
It's my name, Carla Orellana.
Okay, and I'm sorry, ma'am, is that CA?
Yes, ma'am.
CARLAORANA?
ORELLANA.
Okay, I apologize. ORELLANA.
That's correct.
Okay.
758@gmail.
Okay. Communication between you all is going to be via email at this time. Mr. Arias, what is your email address?
Yeah, EARIASARCINEDA@gmail.com. All the properties involved have my email address.
Okay, hold on. ERIAS.
ARCINEDA@gmail.com.
Okay. Having communication right now via email will assist both of you all in just sticking to the subject. And if you go off topic or there's any bad language, then obviously there's going to be proof of that in the email. Okay?
Mm-hmm.
So communication will be via email. It's very important that you all communicate with one another, especially over the next 4 weeks. So if for some reason Mr. Arias has to call you, Ms. Orellana, please answer. Mr. Arias, if there's some reason that Ms. Orellana has to call you, please answer. Now, Mr. Arias, you are currently working, is that correct, sir?
Yes, ma'am.
And what are your work hours?
6 to 2 p.m. 6 a.m. to 2 p.m.
Okay, sir.
Which would be 5 to 1 your time.
Who will be watching your children while you are at work?
They have professional daycares.
Okay, so you will be having them in a daycare facility?
Yes.
Okay.
Also, they'll be spending some time with their cousins. They're in town from all over the country. So they'll want to have like sleepovers and stuff like that sometimes. It's the summertime.
Okay, let me remind you, the time with your children is with you. So
Yes,
I
ma'am.
understand
Yes, ma'am.
that there'll be some sleepovers with their other cousins, but you are to provide Ms. Orellana with the name, phone number, and address of the daycare facility that your children will be in, okay?
Yes, I'm aware of everything.
Okay. And I'm sure that your attorney will make you aware that your children are not to be around anyone that or stay with anyone that has been convicted of a sexual offense.
Mm-hmm.
And that is the same for you, Ms. Orellana, okay? Okay. It's important that you leave your children attended at all time, okay, Mr. Arias?
Yeah, as long as they're with me, they'll never be like not being watched.
Okay. So Right now, the way I have it is that for this summer, your visitation will be on July the 2nd through August the 5th.
Yes, ma'am.
There is to be no disparaging remarks between the parties, no talking about this litigation with the children, no talking badly about mom or dad with the children or any of their family members. And a working email and a working phone number of both parties must be given to each other at all times. Also, I need for y'all to exchange your physical residential addresses.
I have a couple of those, but they need the one because I keep a summer rentals. Would she need both of those?
Wherever your children are going to be residing with you for the next 4 weeks, she will need that.
Okay.
And also wherever you will be residing after August the 5th. So in case there's any communication that she needs to send to you.
Okay.
So when you call in Miss Oriana to Mr. Guerra, please give him your physical address. And Mr. Arias, please give those addresses to Mr. Guerra so that he can give them to Miss Oriana, okay?
Yes, ma'am, they have them.
May I speak? I just want to point out that I do work evenings. Here I don't have reception. So I believe that they need my phone number for work if they were to try to contact me, because I do not get reception here where I work.
Well, by law, both of you have to exchange where you work and the address of where you work and the phone number of where you work. So that's
Okay.
another piece of information you all have to give one another.
Okay.
Okay. Now, Miss Oriana, would you be able to be free between 5 and 6 p.m. Central Standard Time to talk to your children, or do you work during that time?
I work during that time, but I can take time off to speak to my children.
Okay. So if they'll give you a break during that time so you can call them during the next 4
Yes.
weeks. Okay. What else do we need to cover, Mr. Guerra?
Your Honor, the temporary injunction, I'd ask the court to carry that until the dependency duration of this case, for the kids to remain in Hidalgo County. Let's see here. There is child support that is going to need to be paid in the amount of, I believe it's $325 per month.
Okay, so right now I'm not going to take up any issues with respect to child support or anything like that. I wanted to get the summer visitation because I'm going to give you another hearing date to come back. Now, with respect to the temporary injunction, are you asking for just a standard temporary injunction?
Yes, Your Honor, specifically that the kids not be removed from Hidalgo County during the pendency of this action.
Okay, Ms. Oriana, do you have any plans of moving out of Hidalgo County at this time?
No, ma'am.
Okay. Then I will grant that request during the pendency of this case. Only during the pendency of this case will the children be restricted to Hidalgo County, okay?
Yes, ma'am.
I'm gonna have you all come back on August the 23rd at 11 a.m. At which time we'll see how summer visits went. Ms. Oriana, if you have new counsel, they need to appear at that time, August the 23rd at 11 a.m. If you do hire a new counsel before then and they file anything, that's fine. We'll take it up as they file.
Your Honor, just to be clear, and I'm sorry to interrupt, but the time that you've requested or that you've made an order to visitation by my client, that's July 2nd to August 5th. The children need to be back on August 5th by 6:00 p.m. Is that correct?
Yes, or I mean, because they're flying It'll depend on what the flight times are. I'm not gonna force a time and have the flight be maybe like an exorbitant amount. Like they just need to be back
Yeah.
by August the 5th.
If I may say something, when you're traveling alone as a child, it has to be in the middle of the day. So it would definitely be before 6 o'clock. So
Okay.
it can't be the first or the last flight of the night. It has to be somewhere in between.
Well, I'm still not gonna put a flight time, a time, because you never know about delays. You never know about
Yeah.
They
And
just
it's
need
gonna be hard because it has to be a direct flight. That's another thing. So it probably had to be Chicago Airport or Indianapolis or something. So I would have to travel to put them on the plane.
Okay, so the sooner that you get that information to communicate it to Miss Orellana, you have her email address, the better, because she needs to prepare her children, y'all's children, and needs to get them packed up and things of that nature. Now, don't play games, folks, okay? Because technically, legally, all she really has to do is get them on the plane and she can send them with no clothes, but don't do that.
No, that's fine. I'd rather prefer they travel with no clothes.
No, I'm not gonna do that, okay? What I would say though is, look, if you don't wanna deal with checking in bags or anything like that, because it's harder with the minors, is, okay, try to work out what they can take on a carry-on or a backpack. It may not be a lot of clothes, so you will be responsible for getting them things when they're over there, okay?
Oh yeah, I'm not worried about. Yeah, that's fine.
Okay. So,
yeah, that's fine.
but it's just easier if they travel with the carry-on or a backpack instead of dealing with bags being checked in, okay?
Yeah, I know.
So just make sure that they have their essentials at least, Miss Orellana, because it's too much for them to check in bags. So if they have a little carry-on each, that'll probably work for them.
And if they have their own boarding time and stuff, they get to meet the pilot and the attendant. It's pretty cool. It's a good experience for kids.
Okay. Well, let's see how this goes.
Yes, ma'am. Thank you very much.
Yes, ma'am. We will take it from here, okay? Now, Miss Orellana, Mr. Guerra is going to reduce all of this into writing. So now that he has your email address, he's going to email you the order. You will need to sign that order. So review it very, very carefully. And I'm assuming since this is going to take place on Friday, he'll probably get that to you within the next day or so that he can make sure that it's sent in plenty of time to the court to have my signature on it in case there's anything that comes up. Look, your case is in my court now, which means that anything that comes up in the future, it's going to be here. So let's get to know each other very quickly. I'm a straight shooter. I don't like games. And that's what I expect from both of you all, okay? Your children are my first priority, not your feelings. You want me to make any decisions, then I'll make the decisions. Other than that, I expect that you all are adult enough to make some decisions on your own. At this time, this is all we're going to talk about for today. And then next time we come back, we'll see where we're at with the child support and everything else. And if need be, at some point, I am going to send you all to mediation, okay? So just so y'all know that. Okay. Mr. Anything else?
No, Your Honor. Thank you so much. May I be excused?
Yes, and best of luck to you all. And I hope that this visitation goes off smoothly and is an easy transition, okay?
Thank you, Your Honor.
Thank you. I appreciate your time, man.
Okay.
Mr. Guerra, you
Thank
too.
you. Thank you, Ms. Orellana, Mr. Arias, Mr. Guerra.
May I be excused?
Y'all may be excused.
Thank you.
Thank you.
Yes, ma'am.
Ooh.